we say there was an insufficiency of the reasoning. And then the third ground for challenge is that in 44.1a little Roman 3, the award just a dispute not contemplated or falling within the terms of the submission to arbitration. So we say the dispute was outside the scope of the jurisdiction, sorry, the arbitration clause, and to that extent the tribunal exceeded its jurisdiction. And those are the grounds that I mentioned a moment ago in terms of Shawkat Mahassa and in terms of joint and common obligee. So I will start with the Shawkat Mahassa point. I hope I can take it reasonably quickly given your Lordship's own expertise and experience in UAE law. The point is a relatively simple one. WCT was a single member of the joint venture, and if the joint venture was a Shawkat Mahassa, then the claim needed to be pursued by all members, or both members of the Shawkat Mahassa. Now, in order just to make good that assertion briefly, a claim against a Shawkat Mahassa must be brought against all of the partners in a Shawkat Mahassa, and there is authority for that in one of the cases which I'll take your Lordship. Before I do that, I should say that these issues of UAE law are canvassed at some length in a schedule to the to Meydan's skeleton argument. I don't know whether your Lordships have an opportunity to look at that schedule.
It's before me.
I'm grateful for that. What I'm saying is largely reflected in what is in the schedule. There were two authorities bundles that include the authorities to the schedule. So those are two separate authorities bundles. So from now on, when I refer to bundle 1 and bundle 2, it will be of the authorities bundle referring to the authorities referred to in the schedule. So we need to make that adjustment.
Then I have to open that. Will be different than the authority bundles?
Yes, they're bundles which say authorities referred to in the schedule rather than authorities referred to in the skeleton argument.
Okay.
I'm going to start with bundle 1.
I think this is bundle 1.
Lord, yes. And I'm going to tab 8, Lord. And there your Lordship has a decision of the Dubai Court of Cassation. Sorry, 8. In my schedule. Your Lordship has the judgment first of all in English and then at the end, or sorry, then over tab, over the white tab, your Lordship has it in Arabic. I'm going to speak to the English. So this is a decision of the Court of Cassation the 14th of April 2009. And the rule of the text, halfway down the first page, it's agreed in the ordinance of this court, I think really means the decisions of this court, that actual partnership company established between many persons is considered a joint shareholding company, which means for any partner to file a lawsuit or claim his or her share of profits, partner shall file a lawsuit against all partners, otherwise the lawsuit shall be rejected. And then if one goes on to page 5 in the internal pagination, and again, apologies for referring to the English, that is last paragraph at the bottom of page 5. Furthermore, it's agreed on, according to the ordinance of this court, that actual partnership companies between more than one person is considered among joint shareholding companies, which means that a partner who wishes to file a lawsuit to claim his share of profit shall sue all other partners, otherwise lawsuit shall be considered invalid, essentially the same. So that's a claim against a Shawkat Mahassa. And then in terms of claims more relevantly claimed by a Shawkat Mahassa, that is dealt with, decided in the decision in the case of Envirotech, and that is dealt with, that is behind tab 9 in the same bundle. And your Lordship has that at first instance.
Actually, this principle is dealing with the partners between themselves.
Yes.
This is the point here.
Well,
So
I'm
it's not relevant to the...
Well, I'm dealing with Envirotech, which is now a claimed buyer partnership. And they are behind tab 9. I mean, just picking up the logic's point, even between yourselves, if you are a partner and you are suing the partnership, it's still an action against the partnership, even if it's an internal action. And insofar as it's against the partnership, what the court found was you need to join all of the members of the partnership. So in my submission it can be, albeit that on its strict facts, it's an internal situation, it can be more broadly construed. And indeed that is consistent with what is then said in Envirotech, where a claim is made by a share principal master. It has to be brought by, instituted by all of the members of the joint venture.
Okay. I don't know how you're going to establish this.
Well, I'm going to look at this case.
And regard the jurisdiction issue.
In regard to the jurisdiction issue, what we say is if the...
Because my understanding is not relevant to the your case here. It's dealing with a different subject.
Well, no, we aren't. We're dealing with the same subject. And indeed, the tribunal considered it was an issue of jurisdiction. And that's why they dealt with it in their third ruling on jurisdiction.
I don't know how they translate it in English, but in Arabic it's clear for me.
Okay, well, Your Lordship's
okay.
entitled to assert vastly superior knowledge and expertise of UAE law. I can go what is said in this report of the judgment in Envirotech. This behind tab 9 is the first instance judgment, and Your Lordship will then see who the judges were in the court of first instance, including one known to this court, and then
Long time
before the institution. This was 2004, before the JSC had been dreamt of. And then 2/3 of the way down this page, the plaintiff submitted in its capacity as subcontractor indentured the contract with the two defendant general contractors to perform the electrical and mechanical works in a site where works are being undertaken by the defendants. The plaintiff accrued an entitlement to the amount of 2 million dirham odd as a result of performing this subcontract. And then if I could take Your Lordship on to page 3 in this report. As for the defence raised by the defendant's attorney, wherein he argued that the case is inadmissible, having been filed by a party that lacks capacity on grounds that the first defendant entered the contract with the plaintiff and two other companies, namely Al Nasser and Al Andalus, that the case should have been filed by all joint venture members, or at least its leader, since it represents the joint venture companies. This argument is sound. It's evident in the subcontract the first party is the first defendant, and the second party is a joint venture comprising 3 companies, then named. The contract terms indicate the obligations of the joint venture companies for the works assigned to them are combined, acting as a single group, a matter which necessitates the filing of the case jointly by all 3 members. And then picking up the last sentence. Therefore, the court accepts the argument the case is inadmissible, having been filed by a party that lacks capacity. So there are issues both of capacity and of, we say, jurisdiction. Now that then went to the Dubai Court of Appeal. And Your Lordship has that behind tab 10 in the same bundle. And Your Lordship will see that it's the Court of Appeal, and then in terms of halfway down, the appeal decision, the decision rendered in claim number 55/2004, which we've seen is the Envirotech decision. So this is the appeal of the decision of the Court of First Instance in Envirotech. And then if we pick it up at page 3, again, apologies for using the English, as regards the merits of the appeal, and then we can pick it up 5 or 6 lines on. Having said this, it's evident in the subcontract agreement, the basis of this case, that is concluded between the company, first party, and the following joint company, second party, redacted company, head of the joint venture, and then redacted other company, and then redacted other company. This necessitates that if a dispute arises between the parties, litigation should be commenced by and amongst all of them, as opposed to by some of them to the exclusion of the other parties. This litigation has been commenced by one member of the second party of the contract rather than by all members. Therefore, it's filed by a party that lacks full capacity, Therefore, its decision, like decision of the court of first instance, should be granted and awarded. If the appeal judgment makes a determination to the contrary by deciding the case is filed by a party that lacks capacity, that determination should be amended to indicate that the case is inadmissible because it's filed by a party that lacks full capacity. So we say, one looks at this Dubai decision, a decision first of all of the court of first instance, then a decision of the Court of Appeal affirming and upholding the court of first instance. A claim is inadmissible where it's a claim by a Sharakat Muhassab which is being brought by only one member of the joint venture. And pausing there, that's entirely consistent with the underlying position in French law. And your Lordship will be aware of the parallels or the links between French law and UAE law to the extent that there's much of the Egyptian civil code and company law was based on French law by Professor Muhairi, and therefore that came into UAE law, and it's very clearly established as a matter of French law that where one has a société en participation, let's just say a joint venture company or in Arabic a Sharakat al-Muhassab, that the claims must be brought by all members of the Sharakat al-Muhassab. And your Lordship has in this bundle behind tab 14 an article by Professor Dean Giverila, Professor at the faculty at Toulouse. And I'm afraid your Lordship has it only in French, but I can hand it up. Apologies for not getting this to my friend. There we go.
The Arabic version?
No, I'm afraid the English version.
Thank you.
It's only the paragraphs on which we rely. I'm looking at paragraph 9, my Lord. I would hope someone on the other side would have enough French to correct it, right? The translation is not good. Paragraph 9 in the English translation, any lawsuit must be instituted by or against the partners or associates of an individual basis, rather through the intermediary of the manager or owner. Proceedings in the name of a company that has no corporate personality, in this case a société en participation, are affected by a basic irregularity of substance that makes it inadmissible. And then one paragraph further on it gives the example of a banking pool. Since a banking pool has no corporate personality, the leader thereof cannot declare a debt owed to him, her, it in collective proceedings unless he, she, it has been granted a special power of attorney given in writing. The owner-manager can, in fact, ask each participant for the power to take legal action on his or her behalf. So what we're saying is that what is said by the Dubai courts in Berhad is entirely consistent with the underlying French principles. So if we're right about that a Sharakat Muhassab, any action must be brought by all of the partners, the question in terms of jurisdiction is, was the joint venture a Sharakat Muhassab? And it may be worth, at this point, turning up bundle B2. Now, as your Lordship will be aware, the basis of a company under UAE law is contractual. Sorry, what I've taken your Lordship to, or would wish to take your Lordship to, is at the back end of that bundle. So it's starting page 769 in the large numbers, my Lord.
Which tab again?
Sorry, page 769 in the large, bottom right-hand corner, there's a large number and a small number. So I take you in the large numbers to page 769.
I'm confused actually. You're taking it by tab? Which tab?
Well, it's tab 13.
Tab 13.
But then you've got quite a lot of, that's an exhibit, so you've got quite a lot of documents behind tab 13.
Okay.
And then going on to page 769.
I think I'm wrong, Brandon.
Oh, B2. Oh, sorry, I got the wrong model. B2. So it will say volume B, file 2 of 3.
Yeah, I tried. And the page number?
Page number 769.
Yes.
Now, this is what's called the third ruling on jurisdiction. I don't know if your Lordship has had the opportunity to read the final award. The final award includes quite a detailed chronology which sets out, this was a ruling made in December 2014, some months before the final evidentiary hearing, when there was a ruling specifically on jurisdiction, dealing specifically with, amongst other points, the Sharikat Mahassa issue. And that, the Sharikat Mahassa issue starts really at page 80, well, technically at 802. And then going over page to 803, if I could pick up at paragraph 96. For its English translation, provided the Tribunal, Article 654 of the UAE CTC, that's the Commercial Companies Law, provides that a company is a contract, sorry, that's the Civil Code, I apologise. A company is a contract whereby two or more persons are bound to participate in a financial project by providing a share of property or work, the exploitation of that project, and the division of any profit or loss which may arise therefrom. And then it explains a conflict in UAE law that under 656 of the Civil Code, such contract must be in writing. However, by Article 56 of the Commercial Companies Law, the existence of a joint venture company may be proven by all methods of proof. And and then at paragraph 98, sorry, the respondent to succeed had to prove that Arabtech and WCT made a contract which created a Sharikat Mahassa company before the contract of 17th September 2007, since the Sharikat Mahassa company had necessarily to exist before the contract of 17th September 2007. So the tribunal accepts there is a contractual basis, and the issue is there a contract for the division of profits and losses? If I could just pick up those provisions in the Civil Code, in the authorities bundles which I'm now referring, either schedule authorities bundles. If your Lordship has bundle 1, behind tab 1, your Lordship has the Commercial Companies Law. And I should say, for your Lordship's own purposes, if your Lordship wants to follow these provisions in the Arabic, they are behind tab 12.
Take me to the English and which article?
Right, the English is behind tab 1, Lord. And then if I could start with Article 4. So Article 4, the company is a contract by which two or more persons undertake to participate in an economic project intended to make profits by each providing a share of funds and effort, and to divide the profits or losses resulting from the project between them. So picking up essentially what we were discussing a moment ago in terms of the Civil Code and Article 654 of the Civil Code. And then Article 5 lists the various types of company under UAE law, one of which of 3 is a joint venture company, that is a Sharikat Mahassa. And then over page Article 8, with the exception of joint venture companies, the company's incorporation contract and any amendments thereof must be written in the Arabic language and certified by the competent official authority. So a Sharikat Mahassa is spared the procedural requirements in terms of formal incorporation and being publicised. And then again, Article 11, with the exception of joint venture companies, the company's incorporation contract and every amendment thereto must be publicised. So there's two requirements: the requirement of registration in Article 8, and the requirement of being publicised in Article 11, from both of which the Sharikat Mahasa is exempted. And then lastly, Article 12, again with the exception of joint venture companies, a company shall not have a juristic personality and shall not commence its business except after registration in the commercial register. So in other words, a company must be registered unless it is a Sharikat Mahasa, and it doesn't have legal personality as a company unless it's been registered, with the exception of a joint venture company. So there is some implication there that a joint venture company will have a separate legal personality. But essentially it's free from the formalities. Now in terms of the types, we say consistently there are two types of Sharikat Mahasa, and one gets this from Article 61. So in the same, let's say in the commercial companies law, so if one turns on behind the same tab to Article 61, so reading that, a third party shall not have any recourse except only against the partner with whom he has dealt. If the partners perform an act which provides information to third parties about the existence of their company, then the joint venture company may be deemed as a de facto company whose partners are jointly liable towards third parties. So we say there are two distinct types of Sharikat Mahasa. First of all, a hidden Sharikat Mahasa, where the partners may not be known to the third party with whom one of them is dealing. And alternatively, there is an open Sharikat Mahasa. And in those circumstances where the existence of the company is known to the third party, then the joint venture company is deemed to be a de facto company, and the partners are jointly liable to third parties. And that, when it says jointly, it means they're, in terms of solidarity, tadam, so alawajah tadam. So it's got that sense of solidarity. So it's a very particular consequence of the joint venture, the Sharikat Mahasa, becoming open rather than hidden. Now, just while we're still dealing with this anatomy of a Sharikat Mahasa, the cases tend to suggest that actually a Sharikat Mahasa doesn't have separate legal personality. And I can make that good by just taking your lordship very quickly to two cases. The first is behind tab 5 in this bundle. This is a decision of the Union Supreme Court in Judicial Year 23 in 2003. And then paragraph 2 of the summary of the judgment, the effects of Articles 56 and 57 of the Commercial Companies Law is that a Mahasa company, joint venture, is a veiled hidden company that has no corporate personality. So that seems fairly clear, a view of the Supreme Court, that actually it doesn't have corporate personality. And then the next tab 6. So if I could take you to tab 7. And this is the Court of Cassation in Abu Dhabi, Judicial Year 3, Case 111. And then reading from paragraph 1 of the summary of the judgment, provisions of Articles 56, 59 and 61 of the Companies Law together show that a Mahasa company is a commercial company contracted between two or more persons. It's limited to the relationship between them and has no effect with regard to third parties. It is a hidden company that is not subject to registration on the commercial register and has no existence except as between the partners themselves. Thus, it has no corporate personality separate from the personalities of the partners. So again, a judicial statement that there is no legal personality, in terms of a Sharikat Mahasa. So, and the other point I would pick up from that, just while we're passing, is that when it talks about a hidden company, Musatira, it's referring specifically to the fact it hasn't been registered, i.e. that it's been spared being publicised and being registered. It's not a question of being hidden in the sense of being a Sharikat Mahasa that has not been revealed to the relevant third parties. So that allows us now to look at the very significant errors that were made by the tribunal in their third ruling on jurisdiction. And Your Lordship, I've just taken Your Lordship to that in the third ruling on jurisdiction. By way of background, the tribunal in its final award saw fit to confirm the findings of the third ruling on jurisdiction. So to the extent that it ruled on jurisdiction in December before the final award, it repeated and confirmed those conclusions on jurisdiction in its final award. And for Your Lordship to note, I don't think we need to go to it because it's in very similar terms, that is at B1, tab 9, page 73. Right, if one starts at paragraph 100 of the third ruling on jurisdiction.
Will be B1?
Well, let's look at it. B1, tab 9, page 73. It's essentially the final award. It's quite a... So again, volume B, file worth 3.
Sorry, again, will be volume B?
Volume B, file 1 of 3.
Okay, and tab?
And it's all behind tab 9, and I'm going to page 73, numbering the bottom right-hand corner.
Yes, I'm 73.
And we're halfway down that page, F21.6, decision on the third ruling on jurisdiction. And then it recites the fact of the third ruling on jurisdiction dated the 5th of December 2014. And then it deals with F21.7 and following the Sharikat al-Muhassar company issue. And I won't take you to the reasoning there because it's almost exactly the same as what was said in the third ruling on jurisdiction. But if I could take you on to page 79. And there you'll see at F21.10, ruling on third challenge of jurisdiction, paragraph 197, bearing in mind the respondent's submission that if it wished, the tribunal could, for good reason, vary this ruling in this award. The tribunal has therefore reconsidered this ruling. The tribunal has, however, decided there are no reasons to alter either the reasoning or the decision. It therefore confirms the the ruling of the 5th of December 2014. So those errors that infected the third ruling on jurisdiction similarly infect the final award. And in passing, one could add the fact that significant further issues of jurisdiction had arisen between the third ruling and the final award. Because the case of WCT had changed, it was no longer claiming to be a common obligee, it was by then claiming to be a joint obligee. But notwithstanding the issues of jurisdiction that change in case generated, all the tribunal did was repeat its reasoning and conclusions from the third ruling on jurisdiction. So that's all I need to take from B1. If I go back to the third ruling on jurisdiction in B2, and if I could pick up at page 803 in B2, which is the reasoning in the third ruling on jurisdiction. Then if I could pick up at paragraph 100. The essence of a Sharikat al-Muhassar company is that one or more of the partners hide behind the person who deals with a partner or partners conducting commercial business, the ostensible sole owner or trader. But the members of the alleged Sharikat al-Muhassar company were, and had always been, known to the respondent. See the tendering history. Mr. Mahmood, he was the expert for Meydan, suggests that the revelation of one or more previously hidden partners does not mean that the joint venture ceases to be a Sharikat al-Muhassar company. The tribunal accepts that if there are still any other hidden partners, they will still enjoy the limitations on liability conferred by Sharikat al-Muhassar company. But it does not accept that if there are no such hidden partners, the company can be a Sharikat Muhassar company. The purpose of a Sharikat Muhassar company is to give hidden partners protection, which would only be available to members of such a company. See Articles 56 to 63 of the CCL. If the partners are known, the joint venture cannot be a Sharikat Muhassar company. Thus, by the wording of Article 56, the tribunal is of the view that in order for there to be created the form of corporation alleged by the respondent under Article 56, there needs to have been, at the outset at least, one hidden partner. Now actually, the reasoning in that paragraph is confused. On the one hand, they say there has to be a hidden partner in order for it to be a Sharikat Muhassar. And then towards the end of the paragraph, the view has changed somewhat. And the conclusion being expressed is there has to have been a hidden partner, at least at the outset. Now we say that is profoundly counterintuitive, because one would then have a Sharikat Muhassar which is in the open, such as this Sharikat Muhassar, such as this joint venture between WCT and ARB. And in one instance, it would be a Sharikat Muhassar if at the outset there had been a hidden partner. But if at the outset there had not, and if from the outset it had always been an open Sharikat Muhassar, then in those circumstances it couldn't be a Sharikat Muhassar, so there would be a completely different set of legal consequences, merely by reason of whether at the outset, which could have been some years previously, there had or there had not been a hidden partner. And we say that would be impossible for any third party dealing with the Sharikat Muhassar. I should say too that in terms of what we say is a matter of UAE law, that there are open and hidden Sharikat Muhassar. That position that there are two distinct species exists too in French law, and if one looks behind tab 3 in the first of my authority findings, tab 3, your Lordship, there should have the French Civil Code.
Which starts from 1871?
1871, Article 1871 of the French Civil Code. So partners may agree that the partnership will not be registered. The partnership is then called an undisclosed partnership. It's not a juridical person, it's not subject to registration. And then if you could go down the page, about a third of the way down the page, Article 1872-1. Each partner contracts in his own name alone is bound with regard to third parties. However, where the undisclosed partners act as partners to third parties' knowledge, each one of them is bound with regard to the latter of the obligations arising from acts performed in that capacity by one of the others, jointly and severally, where the partnership is a merchant jointly and jointly in other cases. So, quite clearly, that postulates that there being two forms of société en participation, which the first is where it's secret, or where it's undisclosed, and the second is where it's open. There's no requirement that an open société must at some stage, or at the outset, have been a hidden société en participation.
Which is a French term, right?
It is, yes. Société en participation and Sharikat Muhassar are exactly the same thing.
From this hearing, I learned 3 things from you. Speak Arabic, English, and French.
Unfortunately, my French and my English is considerably better. Now, so this is the first mistake that is made in third ruling on jurisdiction. They say, well, it can't be a Sharikat Muhassar because at the outset, everyone knew all of the members of the joint venture, the Sharikat Muhassar. Now, that we say is absolutely wrong as a matter of UAE law. I should say this error is compounded when one looks at paragraph 103 of the third ruling on jurisdiction. So if I could go back to paragraph B2, page 804. So 804. Does your Lordship have, this is paragraph 103 of the third ruling of jurisdiction at the bottom of that page. So in such circumstances, Article 61 has no application. This article presupposes the existence of a Sharikat or Muhassar company where there's a hidden partner that reveals his interest in the company to a third party. In those circumstances, a de facto company comes into existence comprising the partner, who was always known, and the previously hidden partner. So there never was a Sharikat Muhassa company for the reasons given above. No de facto company could have been created or was created. So that essentially is working the point that you need, on their analysis, you would need at the outset to have had a hidden partner. And that, we say, is entirely wrong. And I should say, if your Lordship's interested, that the article by Professor Gibirila on French law also makes the point that you can have a visible société en participation, that you don't need to have a hidden partner or have had a hidden partner. Now, that's the first big mistake that the tribunal made in their third ruling on jurisdiction. The second one, which compounded that error on jurisdiction, was to say that they hadn't had proved to them the nature and terms of the agreement. And this is dealt with at paragraph 99 of the third ruling on jurisdiction. So reading paragraph 99 at page 803 in bundle B2, the essence, notwithstanding the wide terms of Article 56 of the Commercial Companies Law, the respondent fails to prove such a contract. Its submission that the burden laid on WCT is fallacious. The burden of proof lies with the respondent. The respondent relies on the joint venture agreement, but that was made on the 20th September 2007. That is 3 days after the contract of the 17th of September 2007. It also relies on the contract of the 17th September 2007 itself, but the fact that WCT and ARB signed that contract only evidences a prior agreement. It doesn't establish the nature of that agreement. So what is said is, well, there is evidence of a prior agreement, a Sharikat Muhassa agreement, but the respondent, Meydan, has failed to prove that contract. And indeed, if one picks up at that's confirmed again in paragraph 102 in the ruling. Accordingly, the respondent fails to establish that Aerotech and WC had made a contract which would qualify as a Sharikat Muhassa joint venture company. Now, this is in the context where the tribunal has accepted in paragraph 97 that Article 56 of the Company Law, the Commercial Companies Law, finds that the existence of a joint venture company may be proven by all means, all methods of proof. So it didn't need a contract in writing. It would have been enough, it was enough, that there was a contract that could be implied or inferred by means of other evidence. And that's to say the joint venture agreement itself, which clearly evidences a prior agreement, and the contract. Now, if one looks, for example, at the contract itself, one has the contract in this same bundle B2 at the beginning of the bundle. And if your Lordship goes to 477, so this is 477, the contract agreement of the 17th of September. It identifies in its very recitals the joint venture. So recital the third, in terms of the parties, at 3, Aerotech Construction LLC WCT Engineering Berhad Dubai branch, joint venture of, and then gives its address, the contractor. And then over page, clause 3 of the contract, the following documents shall be deemed to form and be read and construed as part of the contract, viz. And then your Lordship sees various contractual documents. And if one looks at little I, that is, such other documents or correspondence itemised in the list of contract correspondence attached here too. And then if one turns on, so one has attached to the contract all sorts of tendering documentation. That includes at page 493 a letter letter from the joint venture of the 30th of August 2007, and that's to TAC, which was the agent of Meydan. Dear sirs, and then the second paragraph, kindly be informed that our new entity shall be ARB Construction LLC hyphen WCT Engineering JV joint venture in lieu of a tendering joint venture. Further, kindly be informed that our account name of page received monies from the employer shall be ARB WCT joint venture JV. So, as a contractual document, that is very powerful evidence, we say, that there was a joint venture, that it had a single joint venture account. And in terms, true it is, in terms of the detail, well, that comes in a joint venture agreement. My learned friend referred this morning to a core bundle, which is a bundle entitled Additional Documents Core Bundle.
Yes.
Now, in the additional documents, you have a, if you turn to the index, the joint venture agreement is behind tab 2.
Yeah. Araptic
And WCT. So this is the joint venture agreement. Now, the tribunal was right in saying this was the 20th of September. It was concluded and formalised and signed 3 days after the contract itself. But it is, in our submission, inconceivable that the parties would have entered the contract with Meydan and would have set up a joint bank account for the receipt of monies in circumstances where they hadn't first agreed the joint venture agreement. And so we say this is the gap of 3 days is merely a matter of formal execution. Just so that one has a sense of the joint venture. Perhaps the quickest route to that is Article 5 of the joint venture agreement, which is, I don't think I have pagination, but if your Lordship could go to Clause 5 of the joint venture agreement. I'm grateful, page 8. So 5.1, the respective participations and interests of each party in the joint venture shall at all times be in a percentage share set out below. Aerotech 50%, WCT 50%. And then 5.2, all rights, interests, assets, liabilities, obligations, risks arising out of this joint venture agreement or the contract, and all profits and losses arising out of all joint performance of the joint venture work shall be shared and or borne by each party in accordance with the proportion of its profits of its percentage share. That's, I think, all I really need. So it's a 50-50 joint venture in terms of the profits, the distribution of profits, not the actual receivables, but the profits. Once there's been an internal accounting of what the costs and who's put in what costs and what effort. So true it is that this was made, this agreement was formalised 3 days after the contract. But the contract itself had already provided the nature of the joint venture, the parties to the joint venture, the provision for a joint venture bank account. So in our submissions, it is extraordinary for the tribunal to say, well, no, there isn't a Shariat al-Hasan. Because although the contract, the joint venture contract, clearly existed, you haven't proved the nature and the terms of that joint venture agreement. And the third error in terms of the third ruling on jurisdiction, if one could go back to pages 803 and 804, starting at 803, sorry, 804, apologise. I've read the first 6 or so lines, but the last sentence on this page, page 804, the contract of 17th September 2007 defines the extent of the rights, liabilities of the contracting parties and the legal status of the joint venture or consortium of Aerotech and WCT. Clause 6, the contract states, and then essentially joint and several liability of the joint venture parties, and then paragraph 104 subclause 114 of the FIDIC General Conditions, again a reference to joint and several liability. And then at paragraph 105, these provisions, i.e. for the joint and several liability of the joint venture parties, which was stipulated by the respondents as part of the contract established between Aratec and WCT, are the exact opposite of a single corporate entity. So they're saying, well, this shows that it can't have been a single corporate, it can't have had separate legal personality, and therefore it can't be a sharikat muhasa, because look, here's provision for the separate joint and several liability of the parties. Well, again, when one's looked at the authorities, one can see that the UAE courts don't believe that a sharikat muhasa has separate legal personality. So, as a ground for saying that isn't a sharikat muhasa, that simply doesn't work as a matter of UAE law. The UAE courts do not have held on a number of occasions, as we've seen, that a sharikat muhasa doesn't have separate legal personality. So to say, well, because there's joint and several liability, therefore there can't be a sharikat muhasa, is obviously wrong. It's obviously wrong too, because the FIDIC provisions for joint and several liability are entirely commonplace. And the effect of this would be, if that was right, any joint venture, contractor or subcontractor on FIDIC terms with separate joint and several liability could not be, as a matter of UAE law, could not be a sharikat muhasa. Well, that law is, with respect, is obviously wrong as a matter of UAE law and as a matter, therefore, of deduction. I should say I'm harping on about French law, but French law has the same position, i.e. that a société en participation is not a juridical person, does not have separate legal personality. Yes, we saw, didn't we, because we looked at the Article 1871 of the French Civil Code, which has expressly provides to that effect. And lastly, at the end of the judgment or the ruling, there's reference to the fact that the parties entered the deed of renouncement and the partial termination order, so they effectively severed their interests. And so the tribunal says, well, because the parties believed they had severable legal rights, that means that it couldn't have been a sharikat muhasa. But that's simply wrong again, because the partial termination order and the deed of renouncement was some 5 years after, or even 6 years after the agreement. And all that shows is that 5 years after the contract, the parties wanted to sever their rights, and did, we say, sever their rights. That doesn't mean that 5 years before they didn't enter the contract as a sharikat muhasa. So that, we say, again, is a thoroughly bad point. And lastly, paragraph 110, the tribunal referred to a decision of the Dubai Court of Cassation in 2008, and that is case 342 of 2007. And this is a case they keep coming back to. There's a 5-line summary bit at page 806 of the third ruling on jurisdiction. That 5-line quotation says as follows: it is also established that if two companies are named as consortium in a contract, then such fact does not make them as one company, or even a juridical personality other than them, or even prejudice the right of each one of them to litigate in its name. Now, you may have seen in the skeleton, and we say this has been taken out of context, because this is a case about consortia, so about ihtilaf. And it's a question of whether a legal action can be brought in the name of a consortium, or which has no legal personality, or needs to be brought by the parties themselves, the parties to the consortium themselves. And the case makes clear that no, the parties to the consortium need to bring the action themselves, all of the parties. And actually, not only is the passage in 110 taken out of context, because it's clearly in the context of whether a consortium can bring an action in its own name, or whether the parties to the consortium need to bring the action. And that's what the judgment is about. But it's also arguably even a bad translation, in that where it says each of them, and that's the word that they really rely on. In the Arabic, it's kilminhuma, so it could be both of them as much as it could be each of them. So one translation is each of them, but equally kilminhuma could also be both of them. So actually the Arabic doesn't bear the weight that they seek to put on it. And you'll see that section, those 5 lines from that decision is repeated both here in the third ruling on jurisdiction and in the final award, and in the final award on the issue of common or joint obligee. And if your Lordship wants to read that, that judgment is behind tab 11 in Authorities Manual 1. So I'm looking at the English. This is the certified translation that Meydan had at page 3 in the English. It picks up about halfway down page 3. In their 4th ground, the appellants criticised the judgment for involving unsound reasoning on the grounds that the judgment had replied to the pleading, by which the plea is that the case must be dismissed for being filed by a party that lacks capacity against parties that lack qualifications as well, by a brief ground in which the court stated the subcontract in question is signed between the appellant and the 2 respondents as a consortium, and hence the case should have filed against the consortium as a whole, not to each singular company in such consortium. And then over page 4, it's also established that if 2 companies are named as consortium in a contract, then such fact does not make them as one company, or even create a judicial personality other than them, or even prejudice the right of each or both of them to litigate in its name. So again, dealing with the issue of separate legal personality of the consortium. The word consortium simply means that the 2 companies share the same interests and obligations arising out of the contract. And your Lordship has the Arabic over page, and if you go to page 12, about 5 lines down, you'll see that section from Min al-Muhairi, dealing with, again, in brackets, the next line, Ihtilaf. And then at the end of that line, Kul min huma. So we say that is a case about a consortium. It's a case about whether a consortium has separate legal personality and can bring a case in its own name. And the clear finding of the court was no, it can't. But that, in our submission, has nothing to do with whether a single member of a Sharikat Muhassa can bring a claim for the Sharikat Muhassa on its own. So we say, when one looks at that concatenation of errors in the third ruling of jurisdiction, it's quite clear that the tribunal did not have jurisdiction to hear a claim brought by one member of the Sharikat Muhassa, purportedly as the Sharikat Muhassa. I should just say, in terms of the case, what the tribunal upheld was WCT's right to bring a claim on behalf of essentially a consortium, I reference that authority. The pleaded claim one gets from core bundle. So if I could take you back to the core bundle. Behind tab 5, and then para 2.5. So, reading from para 2.5, joint venture. The claimant formed an unincorporated contractual joint venture with ARB to execute the works, the terms of which were recorded in the joint venture agreement.
Excuse me?
Sorry, please.
From which paragraph are you reading?
Sorry, I was reading paragraph 2.5 in Lord. That's behind tab 5. This is their last statement of claim. So once ARB had withdrawn from the proceedings, pursuant to its deed of renouncement and the partial termination.
Okay, joint venture, right?
That's it, yes. So 2.5, the claimant forms an unincorporated contractual joint venture with ARB to execute the works. So that's the pleaded case. The terms of which were recorded in the joint venture agreement. That's the same joint venture agreement that the tribunal has chosen to ignore. Meydan was at all times fully aware of the status of the joint venture between the claimants and ARB. And then, if I could go to apportionment 2.9 over page. The claimant is, on the basis as in paragraph 2.6, a party to the contract jointly with ARB. The claimant is entitled at law to recover the claimant's share. So it's a claim, we say, as a common obligee to a share of the rights and entitlements. And then there is reference to 439, but then at 2.9.3, accordingly, co-obligees are each entitled to claim their share of any rights or debt. And then 2.9.4, the joint venture agreement prescribes a clause 5, which we looked at briefly a moment ago, ARB and the claimant's participation in the joint venture together with their respective responsibilities and liabilities. Clause 5.1 of the JVA provides, and then we looked at that, that's the provision in respect of the percentage shares as defined, so 50% ARB, 50% WCT. And then clause 5.2, which we looked at a moment ago, and then 2.9.6, picking up in the pleading, pursuant to clauses 5.1 and 5.2 of the Joint Venture Agreement in the Civil Code, Articles 439 and 442, which I should say is a provision dealing with common obligees, all profits and losses arising out of the performance of the work shall be borne in accordance with the percentage share, so that's on a 50-50 basis. In consequence, the claimant is entitled to 1/2 of the receivables due pursuant to the contract, and the rights entitled to the claimant and ARB as between each of them shall be determined pursuant to the Joint Venture Agreement and law. And then if your Lordship turns on to paragraph 11 in the same pleading, so again trying to understand what their pleaded case was. So right at the end of the pleading. Here we have 11 relief or remedies, the prayer as we call it. 11.1.2, pursuant to the terms of the contract, the joint venture agreement and applicable law, the claimant is entitled to and seeks its share of the receivables due under the joint venture. As ARB and the claimant operate on a 50-50 joint venture, the claimant is entitled to and seeks an equivalent share, namely 50% of the receivables set out below. So again, it's a share, a claim to a share of the receivables. I mean, we say that's fundamentally wrong on any basis because what the joint venture partners were entitled to was a share of any profit left after the accounting for all the costs of the joint venture partners. So to claim as WCT divine that they were entitled to 50% of such monies as should have been received from Meydan is in our submission to claim an entitlement to a very significant windfall. But that was the pleaded case, i.e. common obligees entitled to a 50% share in the receivables. Just so that we understand the evolution, we then get a completely different claim that's brought at trial. That one gets from the claim that's written openly. So if one turns on to tab 6 in the same bundle, this is the written opening, a very substantial document from WCT Divine. The infamous paragraph 205, is at page 89 of that document. Page 89. So this we say is a complete change in their case by way of their written opening submission. 205 reads as follows. Meydan pleads repeatedly in its response the tribunal has no jurisdiction in relation to WCT's claims because they are brought under the JV agreement, an agreement to which Meydan is not party. However, WCT's claims are not brought under the JV agreement. The position is as follows. And I should say clearly in the pleaded case they were brought under the JV agreement, so that is a complete change in case. The position is as follows. WCT has the joint and several rights under the building contract to claim the whole amount due to the contractor, so they're claiming to be a joint obligee, as is made entirely clear by inter alia paragraphs 2.9.1, 2.9.6, those we just looked at, of the Statement of Claim version 5. It is right that under the building contract, and not a right under the JV, which WCT seeks to enforce in this reference, and actually 2.9.1, 2.9.6 were claims to a share, not to the entire entitlement of the contractor. And then picking up at C, WCT could seek 100% of the claim due to the contractor. It has, in enforcing its rights under the building contract, confined itself to claiming 50% of the sum due to the contractor under the building contract, on the grounds that this reflects the percentage share, that being the defined term under the JVA. This approach is consistent with, and then 2, the understanding implicit in the partial termination order that Aerotech shall have no claim on the amount recovered by WCT in these proceedings. Now, I should say that that was very upsetting to Aerotech. Indeed, Aerotech wrote, as I understand, to Clyde & Co., complaining that this was clearly in breach of the partial termination order, this idea that the entire amount was payable or could be claimed by WCT Dubai, and indeed that Aerotech had forfeited even its right to any recourse as against WCT Dubai. So it was an extraordinary claim for WCT Dubai to be making. Now, just turning over page 206, the JV agreement is therefore relevant only insofar as it explains the source of the adopted share of the amount due to the contractor under the building contract that WCT seeks in these proceedings. So it was saying essentially we are, in fact, joint obligees. We're entitled to 100% of the sums that Meydan is required to pay under the contract, but we, in our ultimate generosity, have decided we're only going to claim 50%. And our reason for that is because that was our percentage share under the JVA, which is otherwise irrelevant. Now, one might wonder why it is that WCT suddenly changed their case from their pleaded case of common obligee to their repleaded case, if you like, that they were a joint obligee. Now, the problem with their case as a common obligee was that there were only two bases for sharing. The first basis was obviously the JVA itself, which gave a 50% split of the profits. The trouble with the JVA is that the tribunal had already found it was post-contractual. So they realised that they weren't going to get a 50% share based on the JVA. The only other practical basis for a share for dividing the receivable under the building contract would have been the cost or the value of the works done by WCT. So if the extended WCT had expended any amount in doing works themselves or in subcontracting, they could have been recovered. That would have provided a sensible basis for providing a share of the receivable. Now, your Lordship might have seen, there was a bit of an issue about the licence of WCT Dubai, in that its licence, which your Lordship may have seen in file B2, let's look at that quickly. In the contractual documents, which we were looking at just now, the licence is at, it's at page 490 in bundle B2.
That one. Bundle B.
Bundle B. Why calling it B2? It says volume B, file 2 of 3 on the front.
Which tab?
The tab 13. There is only one tab.
This one. Only one tab.
There is only one tab.
Yeah, which is the.
Okay, so if I could take your Lordship to page 490 in that bundle.
490?
Yes.
The trading license.
Yes. So this is the commercial license. And at the bottom of the commercial license you will see, or you may see, it says licensed activities. And then in the English, on the left-hand side, sewage and drainage contracting. And then on the Arabic it says contracting for the installation of sewage and drainage networks and their repair. So in other words, this was a very limited license in terms of what they could do. And the tribunal had already made findings in respect to the license that there may be an issue of illegality if they were to seek to recover monies for works that were unlicensed. And that one finds at pages 807 and 808 of the same bundle. So paragraph 114 to start with. By Article 314, a foreign company may not carry out an activity within the UAE without obtaining the requisite licence. And then there was an issue about whether the contract itself is void for incapacity if the works required were outside the scope of the licence. And then at paragraph 115, there's a reference to the narrowness of WCT Dubai's licence. It was limited to the installation, maintenance, drainage and sewage plant. Then paragraph 117, whilst the tribunal accepts that commercial licenses in the UAE are not tradable and exchangeable between entities, the respondent would be required to show that WCT actually completed works or intended to complete works that it was not licensed to complete to show that the contract was unlawful. The respondent has not done this. There's no evidence in either the contract or the joint venture agreement that establishes a division of works that WCT was participating in or had intended to participate in works that it was not commercially licensed to complete. So it's saying, well, that isn't yet shown, but it's accepting as a broad proposition that if works have been done outside the scope of the licence, there would be issues about recoverability. And I should just say that's continued over page 121, sorry, paragraph 121. Thus, the tribunal understands that the crux of the response argument is that insofar as WCT has itself carried out activities that went beyond the terms of its licence, any losses thereby incurred are irrecoverable. Then paragraph 122, and then last sentence of 123, paragraph 123, the respondent argues simply that WCT cannot bring claims related to works which it was not licensed to complete. In the tribunal's view, this must be a question of fact which was not and cannot be investigated at this stage. Indeed, it's accepted in the course of the preliminary hearing it's not a jurisdictional objection. However, the tribunal is not satisfied at this stage that even in the manner in which the proposition is now expressed is correct. So, going on over page, paragraph 127. Accordingly, the tribunal considers the argument posed by the respondent on its fifth ground either fails or is not a matter of jurisdiction. It does not fall for decision by the tribunal at this juncture. The tribunal considers the secondary proposition to be a substantive argument that may be made by the respondent in its defence in the main proceedings of this arbitration. So, the concern, one can speculate on the part of WCT Dubai, was that if they were going to be arguing that they were common obligees entitled to a share, that share couldn't be by reference to the JVA because that was a post-contractual document. And to the extent it was by reference to the works actually done, then if they needed to show and prove those works, they were going to have issues because those works could only be within the sphere of the repair and installation of drainage and sewage works. So they were going to face very major difficulties if they pursued their claim as a common obligee. That is why they had then to reformulate their case in the written submission as that of a joint obligee. That is why what then happens is a certain amount of procedural manoeuvring. So, for example, when Meydan sought particulars of the works done by WCT Dubai, that was refused by the tribunal. And your Lordship has that in file B1.
with your number.
Sorry, this is file, volume B, file 1 of 3.
Volume B,
File 1.
file 2, this I have it here.
Sorry, page, tab 9, page 81.
Tab 9.
The Lord, yes.
Okay. Okay.
Well, but just before we start, I should start to give a little bit of explanation. We do say there are significant procedural concerns about the way the tribunal conducts itself. And we focus on some particular procedural manoeuvring by WCT Dubai. And we highlight three points. First of all, their refusal to provide the further information, which we're just about to look at. Secondly, their reformulation of their case from common obligee to joint obligee, which we've already looked at and we'll come back to. And thirdly, their failure to provide any significant argument or authority on the joint obligee point. Essentially, they left the tribunal to flounder around on its own in terms of whether it was joint obligee or a common obligee. And it was never properly argued. And that is why you have, in our submission, the insufficiency of reasoning of the tribunal. And it's those three things which we say produce a significant procedural unfairness. So looking at the first, and I'm just taking the Lordship in terms of the reference to the request for further information, paragraph 205. On the 12th of February 2015, the respondent submitted a request for further and better particulars, the request.
Again, page?
Sorry, page 81.
Yeah.
So, 12th of February 2015, respondent submitted a request for further and better particulars, request. And then 206, second sentence, the respondent argued that further particulars were necessary. And 207, the respondent argued that as a result the case should be confined to the second claimant's losses against the respondent and restricted to work that the second claimant was licensed to carry out and the costs and expenses that could be individually attributed to the second claimant. In 208, the request related particulars and documents that identified works that fell within the second claimant's license to operate in Dubai into the second claimant's receivables due under the JV contract. So the Meydan had been invited by the tribunal in its third ruling to consider this issue of illegality. And the tribunal had expressly said that that was an issue for trial. And they asked, well, can you tell us what it was precisely that WCT did in order, first of all, to establish whether it's entitled to that work as a common obligee, but also whether the works in question are actually within the scope of the license. And then dealing with WCT Dubai's response. In response, paragraph 209, the second claimant objected to production on the basis of the timing, form and substance of the request. So it's a procedural objection. This is too late. One should add that this application was made, the request was made some 2 months before the evidentiary hearing. And then paragraph 210, the second claimant further argued that the statement of claim Dubai did not make any new claims. And then the decision follows at F24.2, the decision on the request for further and better particulars. On the 2nd of March 2015, the tribunal determined that the requested particulars did not relate to an issue in the present proceedings. On the submission before the tribunal, the majority of the requests from the respondent were seeking particulars of a case which the second claimant did not advance. This is all rather ironic, given that the case that the second claimant, WCT Dubai, was advancing was about to change, because only days before the evidentiary hearing they essentially repleaded their case. In paragraph 214, finally, the timing of the request was made at a very late stage of the proceedings. The respondent didn't seek leave or offer any adequate justification for the request being made at such a late stage, considering the time that the respondent had to consider the amended statement of claim and the proximity of the evidentiary hearing. Well, that we say is unfair, because what Meydan was reacting to was the third ruling on jurisdiction, which had only come out in December. It wasn't reacting to the pleading of the case earlier in 2014. So that's the refusal to provide further and better particulars. We also cite the reformulation of the case, which we've seen in the written opening submission. And then finally, in terms of the failure to provide any argument authority on the joint obligee point. When one looks in the final submission as to the points that were taken, which is in which is in bundle B1.
Okay, tab.
Sorry, tab 9 B1.
Which is the same bundle?
No, I've been looking at B2, so we're going back to file B1 of 3 rather than 2 of 3.
Which is volume B1 to 3.
B2.
Now we're looking for B2.
Oh, Lord, yes. Sorry, B1. Sorry, I apologise for that. B1.
See, again, I'm in B1.
B1, tab 9.
Tab 9.
Page 173.
Yes, 173. Which is the same bundle what you referred me.
I apologise if I got that wrong. And then one's looking at paragraph 489. The second claimant maintains it has joint and several rights, and then it alleges A, B, and C. Those are reasons why it says it has joint and several rights. Essentially, it relies on the second letter of award. Well, that isn't an argument, it was accepted by the tribunal. And then it refers to clause 6, which is the joint and several liability provision in the contract, and subclause 114, which again is joint and several liability in the FIDIC general conditions. And it says, well, that basically is why we were a joint obligee. But it certainly makes no attempt to engage, for example, with the issues of the underlying issues of Egyptian law, the commentary of Muhairi, the French civil code. None of that was really dealt with, and therefore the tribunal were left, as I said, to flounder on their own. And the combination of those three procedural manoeuvres on the part of WCT Dubai, we say, created significant procedural unfairness. Try and deal briefly with the two types of co-obligees, that's the joint obligees and common obligees. Joint obligees, as your Lordship will be aware, are where the obligee, usually a creditor, can call for performance of the entire obligation. So I'm a creditor, and I can say to the debtor, pay me the entire amount, even though I'm a co-creditor, even though I've got other creditors. Now this is dealt with in Article 439 and following of the Civil Code, which are in Authorities Bundle 1. My Authorities Bundle 1. Sorry, I'm sorry, my Authorities Bundle 1. And at tab 18, sorry, this is the schedule authority. My apologies. Tab 18.
Let me find that.
Of course.
Authority bundle.
Bundle 2.
It is, yes. Schedule authorities 2.
Tab is?
So tab is 18,
Okay.
page 300.
I think I'm wrong one.
Sorry, yes. Within tab 18, your Lordship has essentially various extracts from Wheeler.
There's an articles of civil code.
Yes, Lord, yes. Well, there are various tabs within tab 18, various white tabs.
Yeah.
I'm hearing noises from my left that it's after If you go over, I think that's the one, if you go over the first white tab, you're then into a photocopy of Whelan. And then if one goes within the Whelan pagination to page 300.
300 and?
Just 300, Lord. So there you have the provisions of the Civil Code dealing, first of all, with joint obligees. Does your Lordship have that?
Yeah.
So joint obligees is section 1 of part 5, and that takes you through 436 through 439, the 440. And then at page 302 you see common obligations. Just for your Lordship's benefit, behind tab 29, your Lordship has a table setting out the same provisions, 436 and following of the Civil Code, with the Arabic. And then your Lordship will be aware that the joint obligees regime comes directly from French law, but the common obligee regime comes from Sharia and the Majalla. And so that is dealt with, again, behind tab 29 in what's called tab B, which deals with the common obligee Sharia provisions, whereas table A, also behind tab 29, deals with the French law joint obligee regime. In fact, there are only two provisions that I need to take the Lordship to in respect of joint obligees. The first is Article 436. Obligee shall not be regarded as being joint save by agreement or by law. And we'll see that what is required is the express stipulation that the obligee is entitled to entire performance. So they're entitled to claim the entire amount for themselves of the debt. And then over page 301 is Article 439, which is the critical provision.
Yep.
Joint obligees may claim jointly or severally against the obligor for the performance of the obligation. Jointly and severally isn't very helpful in English, but it's mujtamini and munfaridi, so it's that idea of together or individually. So individually they can claim the entire amount of the debt. That is in distinction, we say, with the provision in respect of common obligations at page 302 and 303. But looking at 302, Article 441 dealing with common obligation. An obligation shall be common if it has the same cause, or is an obligation devolving by inheritance upon a number of heirs, or is property consumed in common, or is consideration for a loan raised with property owned in common. And then at Article 442, each of the co-obligees in a common obligation shall have the right to pay his share therein. And anything received by one of them shall be the common property of all of the co-obligees, in each according to his proportion. So clearly the focus there is on sharing, i.e. the co-obligees are referred to as shurka, and each is entitled to their nasib and their hissa, and they are referred to obviously as common obligees, so an obligation that is mushtarak in the sense of being shared in common. So the very strong emphasis of language in 442 is in terms of shares. In fact, it was accepted by WCT Dubai that the presumption is that an obligation, where there are co-obligees, is a common obligation. It's only where there is an express agreement for the purposes of Article 436 that an obligation is a joint obligation. So they accepted that they had the burden of proving an express agreement that the parties should be joint obligees, because it's an exceptional situation. So that's the primary, the starting point of the analysis is to say, well, look, is there an express agreement? The secondary analysis, or the cross-check, if you like, is to ask, well, is the obligation shared? Is there a strong sense that each of the co-obligees has a share, or is entitled to a share of the performance? And as I've said, that was the case as pleaded in V5 in the statement of claim, i.e. we're entitled to a share of 50% of the receivable. And what then emerged in the written opening submission was a claim to entitlement to the entire amount of the receivable. Now, what then happens in terms of the tribunal? Well, the tribunal got rather confused on this issue. And if one goes to B1, tab 9, which is the final award, page 185, we see how the confusion started. And paragraph 518. Under UA law, a distinction is drawn between joint obligees, where each obligee may claim performance of the entirety of the contract from the obligor, and common obligees, where each obligee is limited to claiming his share of its entitlement from the obligor. Jumping a sentence, the respondent argues by reference to these articles, the original provisions of the French Civil Code and the Arabic version of these articles and commentaries, that unless there is express stipulation in the contract permitting each of the obligees to compel performance of the obligation, then the obligation is to be regarded as common. The question, therefore, is whether the respondent expressly promised, I should say that was agreed. 519, the question, therefore, is whether the respondent expressly promised that each of Arabtech and the second claimant separately to perform its obligations under the contract. In the tribunal's view, clause 5.2 of the contract agreement did precisely that. It made a promise to each of Arabtech and the second claimant separately to make payment of the contract price. This is reinforced by the terms of clause 6, which, as we've said, is the joint and several liability provision. In other words, the parties to the contract were assuming or asserting that because the contractor was an unincorporated joint venture, its obligations and liabilities would be joint and several. The same assumption must underlie clause 5.2 when it refers to the contractor, because it's an unincorporated joint venture of the two parties. The obligations owed to it by the respondent are also joint and several. Now, if your Lordship understands that, then your Lordship is doing better than I am, because I don't understand it. The logic appears to be that because it's not a Sharia Mahasa, because these are an unincorporated joint venture, because therefore Meydan promises to pay monies to the contractor, because the contractor is each of the parties, i.e. WCT and Arabtech, therefore it's making a separate promise to each of them, and therefore each of them is entitled to enforce, and therefore that is an agreement for them to be joint obligees. Now, in other words, that's the same issue as whether it's a Sharia Mahasa. Because it's not a Sharia Mahasa, therefore there are individual joint venture parties, and therefore each of them is entitled to enforce separately. And that, as I say, it derives by a strict reading of clause 5.2, the payment provision, and indeed the joint and several liability provision in clause 6. The problem with the analysis, and the reason it falls down, well, there are a number of problems. First of all, if one looks at the contract, the payment is to be made to the contractor. The payment is in fact to be made into a joint venture bank account. It's not as if WCT Dubai can put its hand up and say, please pay me the entire amount of the receivable under the contract. All that WCT Dubai can do is say, please pay the receivable into a joint venture bank account. Now, one gets that from subclause 14.7, but I can take a look to the core bundle. And behind tab 1 in the core bundle, your Lordship has the FIDIC, the general conditions, or the subclauses, if you like. Tab 1, my Lord.
Again, what's the bundle?
Sorry, it's the bundle which is called, additional documents called core bundle.
Okay. This one.
Although it would help to
think I confused totally with your. No, I have the marker, but let me find your bundle first.
This is the what I'm calling core bundle. I've scribbled core on it. Just so like.
Actually,
It says additional documents core bundle.
this one. Yes. Let me then first clean my disk. Yes,
Tab 1.
Okay. Further conditions?
The fitting conditions, so these are the general conditions. And what your Lordship has here is a markup showing, a consolidated markup showing the general conditions and the amendments made by way of the special conditions. And then at page 54 of the internal pagination, your Lordship has clause 14, subclause 14.7. So 14.7, the employer shall pay to the contractor. So thus far, so good as far as 5.2 is concerned. And then there are various instalments of when they shall be paid. This is the detail of the payment. And then at the bottom, payment of the amount due in each currency shall be made into the bank account nominated by the contractor, by both parties, in the payment country for this currency specified in the contract. And your Lordship will remember the letter we looked at of the 30th of August 2007, which specified the details of the bank account. That was the joint venture informing Meydan of the bank account into which all monies were to be paid. So this provision 14.7 blows a hole in the analysis that WCT Dubai is entitled to the whole amount. It's not. It's entitled to call for the payment of the amount into a joint bank account. So how does the tribunal then deal with 14.7? Well, if one looks in the final award, so going back to B1, and then going back to page 187, this is the analysis of the tribunal. And if one goes to paragraph 521, the provision whereby the respondent was to pay the money to an account opened by the JV, subclause 14.7 of the fitted conditions as amended, is plainly only administrative and doesn't affect the tribunal's conclusion set out above. So they essentially consider themselves able to ignore paragraph 14.7 as a matter of administrative detail. And we say that's plainly wrong in terms of the intention of the parties. Well, first of all, in terms of whether there was an express stipulation that WCT Dubai should be entitled to the whole amount. How can one possibly uphold the argument there was such an express agreement when the agreement itself actually provides for payment into a joint bank account? But even if you're running the cross-check analysis, even if you're saying, well, are the parties really entitled to shares? We say, well, that's clearly the case because this is a JV that was having the money paid into a JV account, so one assumes there are going to be shares within the joint venture. And indeed, the JVA itself, as we know, provided for those shares. How does the tribunal deal with the JVA? Well, that's dealt with at paragraph 524 of the final award. The position is not affected by the JVA. First, it was made on the 20th of September 2007, i.e. after the contract of 17th September 2007. And second, the respondent was not a party. So we can ignore the JVA. Slightly curious in terms of the pleaded case of WCT Dubai, that their share was decided by the JVA. All of a sudden, now the tribunal is saying the JVA has got nothing to do with it, doesn't affect the analysis. In our submission, again, plainly wrong. And we say that the tribunal should have looked at the intention of the parties, and in terms of UAE law, in English law there's an exclusionary principle. The court cannot look at subsequent conduct after the event in order to work out what the contract means. There is no such exclusionary rule either in Dubai law or in the WCT law. The court, in terms of construing a contract and working out what the parties intended, which is the test of construction under UAE law, can look at subsequent events, and could have looked at the JVA. In any event, it could have looked at the pre-contractual correspondence. Because that letter that we looked at, the 30th of August letter, was part of the contract. One of the contractual documents that was exhibited and attached to the contract. And it's quite clear from that document, in that 30th of August letter, that this was a JV, which had a JV bank account in which the monies were going to be received. And finally, in terms of the error in the award, there is a tacit suggestion of what has been called a mutuality argument. And that's to say that if you're jointly and severally liable, so if there's tadamun between debtors, then there must be a similar solidarity or tadamun between the same people as creditors. And that has been, well, that I should say that was advanced as a matter of constitutional law. And one gets this from the transcript, which is in the authorities bundle in authorities bundle 2. Behind tab 37. So this is authorities 2, tab 37, right at the back of that bundle.
Still I have difficulty with your bundles. Now this is authority bundle.
Does it say authorities refer to the schedule?
This is one. You refer me to 2, right?
I'm looking at 2, yes. So if one turns to tab 37, page 31 within the, so your Lordship will see there are 4 pages on each page.
Okay.
Does your Lordship have page 31?
Yes, I have.
About halfway down the page, Mr. Brannigan, who was leading counsel for WCT Dubai at the arbitral evidentiary hearing. Mr. Chairman, can I just make the following point? Whilst in my 2 odd hours I didn't go into every bylaw, just on the point you've made, you had evidence on the record of our UAE legal expert, that's Dr. Muhairi, on virtually the exact point you just made about the need in UAE law for reciprocity of such obligations. So that's what I call mutuality. And then if your Lordship goes on to page 56 in the same transcript. Sorry, little numbers, top right of
The manuscript.
Yes, in the manuscript.
Yeah, okay.
So page 56, my Lord.
Yeah.
And this is me. That raises a question, first of all, of necessary inference, and we say there's no necessary inference, and it raises a second question, I think, Mr. Brannigan's point about there being some UAE law, some inference of mutuality by statute. I'm assuming he's going to tell us it would therefore come within Article 436, arising by provision of the law. Mr. Brannigan, yes, Mr. Reid, I don't want to keep interrupting. What it says in the report is it arises by reason of the constitution of the UAE. This is the mutuality point that was being run by WCT Dubai. And then to see what they're saying, one has to go to My Authorities Bundle 1. Because here we pick up the report of Dr. Muhairi.
And will be tab.
And you'll look at tab 17, my lord, right at the back again.
Page?
Page 17, paragraph 49 of Dr. Muhairi's report. So, paragraph 49, this is the question. Under the law of the UAE, must a claim under contract made by the joint venture of the third party be made by both members of the JV, or is it possible for it to be made by one member only? And what is said by Dr. Muhairi, if I could pick up in 51, paragraph 51, page 18. If the contract with the third party specifies that it's a contract with an unregistered joint venture, and the parties to the joint venture shall be jointly and severally liable to the contracting party, thus giving the third party the right to claim against both of them or either of them, then it can only follow that either party, partner to the unregistered joint venture, shall have the right to claim against the third party. This is a basic and fundamental constitutional right in the UAE. All persons have the right to seek protection of their rights through legal process. No one shall have the right to claim against another and contend that the other has no right to claim against him. All parties are equal before the law. Articles number 25, 40 and 41 of the UAE Constitution elaborate this point. And the learned doctor then sets out Articles 25, 40 and 41. Article 25 is equality before the law. Article 40 is the right of foreigners to enjoy treaty rights. And Article 41 is the right of any person to lodge a complaint before the relevant authority. And none of those, we said and we continue to say, provides any basis for a mutuality argument that where there's joint and several liability or solidarity between debtors, there must be joint and several entitlement, i.e. solidarity between creditors. In any event, what is required is express stipulation. Mutuality argument is an argument of inference, it's not an argument of express stipulation. And my Lord, making good this point about there being no presumption of solidarity, that is fundamental, we say, both to French civil law, but also to the commentaries of Sandori in the Wasit. So if I could just briefly take your Lordship to Authorities Bundle 2, tab 20. Sorry, 2, tab 20. This is our old friend, the French Civil Code.
Start with which article you read?
Sorry, I'm starting with Article 1197, which is dealing with joint and several creditors. An obligation is joint and several between several creditors where the instrument of title expressly gives to each of them the right to demand payment of the whole sum. And then at the bottom of the page, Article 1200. There is this is dealing with joint and several debtors, so solidarity between debtors. There is joint and several liability on the part of debtors when they are bound to the same things, that each one may be compelled for the whole and payment may be made by one and no discharges the other. So that's joint and several liability. And then over page 1202, joint and several liability may not be presumed, it must be expressly stipulated. That's actually a mistranslation because the French, your Lordship, has behind the white tab. And if I could take you briefly to page 5 in the French.
Which is I cannot read the French.
The French is so similar to the English.
Okay.
Do you see that?
Yes.
La solidarity is not presumed. It must be expressly stipulated. La solidarité ne se présume point. Il faut que ce soit expressément stipulé. So it's not joint and several liability may not be presumed, it's solidarity. It refers both to joint and several liability and joint and several entitlement. And then staying in bundle 2, if we could turn on to tab 32. We have here the writings, an article by Professor Muhairi of the University of Robert Schumann in Strasbourg. And then if I could take your Lordship to page 13, which is the English translation of Professor Muhairi's article. And then key points, active solidarity, so solidarity between creditors, joint and several entitlement can only arise contractually. Statute does not provide for any other circumstance. It requires an express provision, in which case law interprets restrictively. And then over page 14, paragraph 3, exclusively contractual solidarity, so it has to be by way of contract. And then over paragraph 4, requirement of express stipulation. And then paragraph 5, autonomy between stipulations of passive and active solidarity. The case law consistently holds that a synallagmatic contract, active solidarity, so solidarity in creditors cannot be inferred from, and should say passive solidarity. So the mere fact that parties are jointly and severally liable doesn't make them jointly and severally entitled. And just so that one can make the link between the French Civil Code and the UAE Civil Code, we've included the relevant section from the WCT. So that's Abdul Razak Ahmed Sahuri, and your Lordship has that behind tab 34, and it's dealing here with solidary obligation. If I could take your Lordship from tab 34 to page 4. So this is a translation of a receipt. Solidarity between creditors is created by agreement or will in general, despite the fact the aforementioned Article 279 refers to solidarity amongst creditors and solidarity amongst debtors and provides solidarity is created by agreement or by law. It should not be presumed that solidarity amongst creditors, simply the solidarity in debtors, should be created by agreement or law provision. In fact, solidarity amongst creditors is created only by agreement or testament, i.e. will in general, and is not created by law. And then over page 5, he's at the top of the page explaining that solidarity between creditors is rare in practice. And then the second paragraph of this page, the reason for scarcity of solidarity amongst creditors is that damages of such solidarity exceed any benefits that may arise therefrom. If the creditors provide for solidarity amongst them, their only gain would be that any creditor can demand the entire debt as much as he can receive it in full. This gain, however, is incomparable to the risk to which the creditors are exposed, as any creditor can receive the entire debt, in which case the debtor will be discharged from this debt. The other creditors can only have recourse against the creditor who received the debt pro rata their respective shares in the debt. If the creditor becomes insolvent, they bear the consequences of his insolvency. This involves a huge risk. And then paragraph 127, solidarity among creditors is not presumed. Since solidarity amongst creditors is created by will or agreement, it cannot be presumed. Unless there is a clear and unambiguous will to create such liability, it will not be created. If, for instance, 3 persons sold their apartment in common, did not clearly prescribe to the purchasers they are jointly, it says liable, but it clearly means entitled. The fact that the apartment is held in common by the sellers will not indicate that they are jointly entitled to receive the price. Instead, the price will be divided amongst them pro rata their respective shares in the sold apartment. In a like manner, if the purchaser has prescribed to the sellers that they should be jointly liable for their obligations towards the purchaser, this will not necessarily mean they're jointly entitled to their rights towards the purchaser. Instead, solidarity in their right should be stipulated as much as solidarity for obligation should be stipulated. So you cannot derive from the fact that someone is jointly and severally liable that they are jointly and severally entitled. That is clearly provided as a matter of French legal doctrine. It's clearly provided by Professor Sanhouri in his commentary on the Egyptian and the equivalent provisions in the Egyptian Civil Code. And we say that's clearly to the position under UAE law. Finally, we we say that even if they were joint obligees at the outset, the position had clearly changed by reference to the deed of renouncement and the partial termination order. That is essentially a division of the claims. So the arbitral proceedings continued in respect of the issues, claims and counterclaims as between Meydan and WCT Dubai, but those proceedings were terminated as regards the issues, claims and counterclaims between Meydan and ARB. And to that extent, that was clearly a sharing, or an attempt to share the rights of the two JV participants. And to that extent, there was a waiver by WCT of its rights to claim all the receivables if it had such a right. And there was an election by WCT to claim only its share. So even if, under the contract, the tribunal were right in saying that they were at the outset joint obligees, it's quite clear once you get to the deed of renouncement and the partial termination order that they each accepted that they were entitled to a share. The analysis then becomes one of common obligees. So those, my lords, are the points in terms of the jurisdiction to hear a claim brought by WCT Dubai for the entire amount. The claim that WCT Dubai was a joint obligee. I've alluded to the procedural issues, the procedural claims. Those are a separate ground. I've dealt first of all with the request. In our submission, the refusal by the tribunal was extraordinary. Not least where WCT Dubai was itself permitted a wholesale amendment of its case only days before the trial. We also say, as a procedural failing, we also rely on the insufficiency of the reasons of the tribunal, and we say the tribunal failed to take into account some very detailed submissions on the relevant UAE, Egyptian and French law. WCT took a tactical decision in our submission not to respond to those submissions. And what then happened was the tribunal was left, for example, with the arguments of Meydan that you can't have mutuality, and the tribunal didn't really have the other side to the argument. There is no other side. And as a result, one sees the reasoning of the tribunal on that issue is infected with the idea that if you're jointly and severally liable, well, there must be some sort of inference that you're jointly and severally entitled. And that, we say, is why the award is so bare in its reasoning. That's why the final award, the reasoning essentially is contained in one paragraph. That's paragraph 519 of the award. It does no justice to the submissions that were put in on Meydan's side. And finally, in terms of procedural unfairness, we say there is a strong inference or appearance of bias. And we say when one looks at the extraordinary number of errors in both the third ruling of jurisdiction and the final award, that in itself gives a strong inference. But when one also adds into the mix the refusal to provide or order the further information, the indulgence of the tribunal to the recasting of WCT Dubai's case, and finally the extraordinary inconsistency between, on the one hand, the tribunal finding there was no agreement to share profits. Essentially, well, there was some agreement, but you haven't proved its terms. So being very demanding about the requirements of such an agreement and how it should be proved. But then at the same time, only a few months later, saying that they did find a stipulation of joint entitlement. So we can find that there was an agreement, an express agreement, that WCT Dubai should be entitled to the entire amount of the contract price. The agreement to share profits could have been implicit, and in our submission it was obvious, and yet the court didn't find it. The agreement, the alleged agreement of joint entitlement, needed to be expressed, and there wasn't so much as a suggestion in our submission of such an agreement. Quite clear on the terms of the building contract that the monies were to be paid not to WCT Dubai, not to ARB, but instead to a joint bank account, where each would have the security of knowing that the other couldn't get the monies out. So we say, when one looks at those two highly inconsistent approaches, that supports our argument that there was a strong inference of bias. So coming back to my starting point, does WCT have a much better argument on the material available on the Article 44.1a issues? And we say when you look at incapacity, when you look at due process, when you look at the excess of jurisdiction, we only need Meydan to succeed only on one of them. But when you look at all of those three, on each of them, Meydan has much the better argument. That is why we say the court should not exercise its jurisdiction. Lord, unless your Lordship has any further questions.
Oh, thank you.
So, Your Honour, just one more small aspect, which I hope to take very shortly, which is material non-disclosure.
Yeah.
Now, I can take it shortly because in my submission the principles are clear, as are the facts in this case. Everyone agrees that a party making an application of this sort owes a duty of full and frank disclosure. The duty is defined in the rules themselves, and it is strict. If I could ask you to go to the first bundle of our authorities at tab 12.
Schedule 1 or?
No, back to my one, I'm afraid. Authorities refer to in Meydan's skeleton argument.
Okay, let me find it. What's that?
Tab 12, page 11. Rule 23.11. On all applications without notice, it is the duty of the applicant and those representing him to make full disclosure of all matters relevant to the application, including in particular disclosure of any possible defences that may be available to the respondent in response to the application. Now the wording of that is very important because it's disclosure of any possible defences that may be available to the respondent. And there is very good reason for that. There is an English case which is very well known, which has been cited by both parties, and I just want to take your honour to that to show you what the rules are. And it is in the second bundle at tab 43.
Second authority bundle.
Yes, my second one, tab 43.
Tab 40.
43, and it's at page 7 of the bundle, or 1356 in the top left.
Okay.
Now it starts at paragraph F. As I say, this is a very well-known judgment and principles, but I do want to take you through them because they're very important in terms of material non-disclosure. So therefore it starts in considering whether there has been relevant non-disclosure and what consequences the court should attach to any failure to comply with the duty to make full and frank disclosure. The principles relevant to the issues in these appeals appear to me to include the following. 1. The duty of the applicant is to make a full and fair disclosure of all the material facts. So that would include a full and fair disclosure of defences. But that is the overriding duty, it's to make full and fair disclosure. That's the first principle. The second one is that the material facts are those which it is material for the judge to know in dealing with the application that's made. Now, the next part of it is extremely important because materiality is to be decided by the court and not by the assessment of the applicant or his legal advisors. In other words, it is for the court to decide whether an issue or defence is material to the outcome of the application, not for the advisors. Thirdly, it's not simply what the party knows, it is also what he should know. So principle 3 is the applicant must make proper inquiries before making the application. The duty of disclosure, therefore, applies not only to material facts known to the applicant, but also to any additional facts which he would have known if he had made such inquiries. And then fourthly, he deals with the extent to which you have to make inquiries, which is the extent of the inquiries which will be held to be proper and therefore necessary must depend on all the circumstances of the case, including the nature of the case and the applicant, which the applicant is making when he makes the application, the order for which the application is made, and the probable effect of the order on the defendant. Fifthly, this is what happens if material non-disclosure is established. If material non-disclosure is established, the court will be astute to ensure that a plaintiff who obtains an ex parte injunction without full disclosure is deprived of any advantage he may have derived from that breach of duty. Now, this is a reference to a quotation where it was an ex parte injunction. We submit that any ex parte application will be treated in the same way if you fail to comply with the obligations of full and frank disclosure. Sixthly, whether the fact not disclosed is of sufficient materiality to justify or require immediate discharge of the order without examination of the merits depends on the importance of the fact to the issues which were to be decided by the judge on the application. The answer to the question whether the non-disclosure was innocent, and this is also very important because the court sometimes allows the order to stand if the non-disclosure was innocent, but innocent means in the sense that the fact was not known to the applicant or that its relevance was not perceived. Now, in this case, and I'll explain why in a moment, in my submission, these cannot be innocent non-disclosures because the relevant facts were known to the applicant. It is an important consideration, by no means decisive by reason of the duty on the applicant, to make all proper inquiries and to give careful consideration of the case being presented. In other words, even if the non-disclosure is truly innocent in this sense, it doesn't follow that the order will still stand. The court is still astute to ensure that you don't gain an illegitimate advantage. Seventh, finally, it is not for every omission that the injunction will be automatically discharged. A locus penitentiae may sometimes be afforded, as Lord Denning said. The court has a discretion, notwithstanding proof of material non-disclosure, which justifies or requires the immediate discharge of the ex parte order, nevertheless to continue the order or to make a new order on terms. When the whole of the facts, including that of the original non-disclosure, are before the court, it may well grant a second injunction if the original non-disclosure was innocent, and if an injunction could properly be granted, even had the facts been disclosed. Now, those principles are extremely important. There is also one decision of this court that I'd like to show Your Honour as well, which is in tab 30 of Bundle 2. And it is the Ithmar capital case, tab 30, and the relevant passages start paragraph 32 on page 11. This is a judgment of Sir Anthony Evans, which you can see from page 2. You'll see the judgment is Sir Anthony Evans, and it's the judgment of the court. In 32, the court held, the judge held in the passages quoted above, that when you come in for an ex parte, the bar is raised very high, and that there was material non-disclosure in the present case. We have no hesitation in holding that he was correct. The principle was stated in Brink's Matt and Elkin, which is the case you've just seen, as follows. The rule that an ex parte injunction would be discharged if it was obtained without full disclosure has a twofold purpose. It will deprive the wrongdoer of an advantage improperly obtained, but it also serves as a deterrent to ensure that the person who makes the ex parte applications realise that they have this duty of disclosure and of the consequences, which may include a liability and costs if they fail in that duty. And then they quote at 33 from another English case, Salim, with Lord Wolfe, who said this: "It is undesirable to apply hard and fast rules. It is preferable, in my view, for each case to be considered on its own merits, taking into account the public interest which exists in protecting the administration of justice from the harm that would be caused if applicants for the draconian relief of Muhairi orders do not, on an ex parte application, make full and frank disclosure of all the material facts, whether or not the non-disclosure is innocent. I recognise the strain placed on legal advisers and the pressure under which they have to work. However, if the court does not approach the question of non-disclosure of material matters in the way that has been indicated in earlier decisions, there will be little hope of solicitors who are subjected to such pressures appreciating the importance of making full disclosure, and more important, bringing home to clients the serious consequences of non-disclosure." Now, a lot of these cases are in the context of freezing orders, and it's important to understand that the reason, when a freezing order is applied for, by definition, the other side is not told about the order, because if they were, they would dissipate their assets. So there's a very important obligation on the disclosure to the court, things that the other side have not yet raised. In this case, obviously, there had been litigation between the parties going on for some considerable time. And I'll explain why that's relevant in a moment. But what the Court of Appeals say in this case, at 34, it is clear from other authorities, which we don't need to set out in detail here, first, that with regard to defences or possible defences which the defendant may rely upon, the duty is not limited to any which he has already raised. The applicant and his lawyer must form an objective view as to what defences there are which, although not yet taken, would have been available to be taken by the defendant had he been present at the application. In other words, the other side have to put their mind to, if the counsel from the other side turned up to court, what would they be saying to the judge? What are the key points that they would be saying to the judge? And they have to do that on an objective basis, excluding only ones which could not reasonably be expected to be taken in due course, or which can be dismissed as without substance or importance. And again, that has to be understood in the context of Brinksmat, which is materiality is one that has to be judged by the court, not by the advisers. And secondly, it is not sufficient to refer to the matter in an exhibit to an affidavit without expressly drawing attention to it. That is very important in this case. Now, in this case, it's very unusual, because what happened in this case was that there was a letter written by my client which set out their case in some detail, and you'll find that in bundle B2. And it's quite a lengthy letter. It's tab 13, which is the first tab.
You find the bundle.
Yeah, B2.
B1 and B.
B2, tab 13, page 370. Yes, 370. The letter starts at 371. You should see at 371 a heading, Kingwood and Mallesons. Now, the letter goes on for some time. It goes on all the way to page 388. But I'm not going to take you through the whole of it. A lot of it covers the ground that Mr. Reid has just drawn to your Honour's attention. But I will just show you at page 376 what is said at 1.12. Key defects and vitiating factors in the award and all the procedures giving rise to it are set out and summarised under the following headings. And I just want to take you to those headings. Section 2, no jurisdiction arbitration agreement with the claimant. Sharikat al-Muhasa. Section 3, no jurisdiction and nullities tainting the award. Absent essential party contrary to public policy, contrary to the arbitration agreement and mandate. Section 4, no jurisdiction and nullities tainting the award. Omission of the minority determination on lack of jurisdiction and failure to consider or include reasons on whether preconditions to jurisdiction satisfied as required in the final ruling on jurisdiction. Miscellaneous nullities in procedure and the award constituting serious irregularities and vitiating factors, 6 of them set out under that heading. Section 6, contravention of public order, disregard of creditors' rights, disregard of mandatory licensing requirements, non-arbitral issues, disqualified tribunal and bias. Now, one thing I hope that your Lordship has seen from today is that there are a lot of issues in this case. The letter was signed off at 388 by Mr. Taylor on behalf of my clients, but that letter set out in relatively brief and short way the complaints that my client had. Now, we say in that context, at the very least, that letter should have been drawn specifically to the attention of the court and its contents summarised, and for the applicant to explain why it says that ultimately those issues made no material difference. But what they actually said was that Meydan had raised jurisdictional and other challenges and said they knew of no reason why grounds for refusing enforcement would be met. And I want to show you where you find that, because that's in bundle B1 at tab 8.
Witness statement.
So this is the witness statement of Mr. Ross in support of the application, which you'll see starts at page 1. At 1.3, I make this statement pursuant to Rule 43.66 of the Rules of the DIC Court in support of the claimant's arbitration claim for the recognition and enforcement of the award dated the 5th of July. If you go on to paragraph 3.6 at page 4, see, 3.6, after initially facilitating the orderly conduct of the arbitral proceedings, the defendant's contribution to the proceedings from approximately the end of 2009 onwards consisted largely of jurisdictional and other challenges to the proceedings. They were not set out or identified. A summary of the challenges made by the defendant is set out in the arbitral award under the heading Procedural History from page 18 to page 88. The tribunal, comprising highly experienced arbitrators, noted in the arbitral award that the proceedings had a long and complex history. Then if you go on to paragraph 4.4, this is a reference to the letter I've just shown you. On the 6th of August 2015, the defendant issued a written reference, purportedly pursuant to DIC Rule 38.4, requesting that the tribunal make an additional award in respect of claims or counterclaims presented in the arbitration but not dealt with in the award. Again, not spelt out. And then if you go on to paragraph 8.1, at page 8, you will see satisfaction of the relevant provisions of the DIFC arbitration law. So this was an attempt to comply with the rules of court. 8.1. I believe that the tribunal's arbitral award is procedurally valid, and I know of no reason why the grounds for refusing recognition or enforcement of the arbitral award under Article 44 of the DIFC arbitration law have been or will be met by the defendant. I am not aware of any other basis on which there would be a reasonable prospect of the defendant successfully challenging enforcement under Article 44. Now that, in essence, was their attempt to comply with the obligation of full and frank disclosure. Now, among the complaints here and in the letter were the points that are made about the fairness of the process, permitting unpleaded allegations, refusal to order further information, why we said the process was unfair, failure to take into account submissions, appearance of bias. None of that was dealt with by the tribunal. Nothing was said about the fact that there was an ongoing appeal to the Dubai Court of Cassation about whether the tribunal's mandate had expired by a fraction of time. Now, all of these matters which are set out in the letter are serious matters which could or may give rise to a defence. They were set out by my own clients in full. All that needed to be done is to take the court to that letter and explain why they said that that case was wrong. But they did not do that. It actually gave a positively misleading impression to the court. All that the court was told is that there were jurisdictional and other objections, and they didn't believe there was any impediment to the enforcement of the award. Now, in those circumstances, that is a plain and culpable failure to make full and frank disclosure. Now, often one gets a party coming to court and saying, we apologise, we misunderstood, we didn't realise the seriousness, we didn't know the facts, or they come to court and make some exculpatory explanation in order to apologise and make the position good. I don't know if you've read Mr. Black's skeleton, but what he says in paragraph 53 of that skeleton, there was nothing to disclose. There was nothing to disclose. And the reason he says that is because they did not disclose anything. And that was a complete failure to comply with the obligations of full and frank disclosure. So, Your Honour, this is quite aside from all the other matters, and it's quite aside from the issue about the misrepresentation of the order to the Dubai court. It's a self-standing ground to discharge the order. There was a letter setting out our case. They should have referred to it. They should have explained it. They didn't do that. It is not an innocent failure because they knew about it. It just simply didn't bring it properly to the attention of the court, and on that ground alone, it is sufficient to discharge the order.
Thank you. Yes, Mr. Black. Shall we take 5 minutes adjournment?
Oops, sorry, my lord. Can I give you, please, a bundle which contains our skeleton and all the authorities in the order in which the skeleton cites them, save for those that are in my learned friends. What I was going to suggest is, given the hour, it would actually save time because my lord said he hadn't had an opportunity to read my skeleton. Yeah. It would actually save a lot of time, both tonight, I suspect, and tomorrow, if you were able to read the skeleton now, when I started fresh tomorrow, and you had it in mind as well.
I don't mind.
Well, my lord, may I suggest that as a useful use of time in case management?
Okay. Then
We have no objection.
no. Then we'll start tomorrow at 10 a.m.
Oh, yes.
Okay. Thank you. And one more thing. No need to refer to the whole bundles here, and I refer to that one, right?
Yeah, my lord.
It's your skeleton argument and authorities.
Yes, my lord. There are references to some of the authorities to which you've been taken already, but anything that you haven't been referred to already is in this single bundle.
Great. Thank you.
All rise.